Welcome back, everyone. I've been roped in to chair this panel because Jill Rutter is at home with COVID, so we wish her very well. She can't join, I'm sure she's joining us online. So welcome to this final sort of cross-person panel before we go into our keynote, where we are talking about the Constitution and the issue of whether or not it should be codified and what that means in practice anyway. We've been talking all day about some of the constitutional issues, some of the concerns that some have about executive overreach, some of the issues around the composite nature of the UK and how that is reflected in our constitutional arrangements. And perhaps the process of codification of the Constitution might help to address some of those issues, or not. And to think about some of these issues, reflect on some of these issues, I'm joined by an excellent panel. To my left, Kate O'Regan, who is the inaugural director of the Bonavero, that's wrong, isn't it?
It's okay, you're doing well.
Bonavero Institute of Human Rights in the Faculty of Law at Oxford University, and a former judge of the South African Constitutional Court. Jeff King, Professor of Law at UCL since 2016, also a visiting professor at the Faculty of Law in Oxford as well. Nick Barber, a Professor of Constitutional Law and Theory at the Faculty of Law in the University of Oxford. Oxford, very well represented here today, as is Edinburgh University. And finally, to my colleague, Stephen Tierney, who's Professor of Constitutional Theory in the Law School at the University of Edinburgh and was the founding director of the Edinburgh Centre for Constitutional Law. So I think we will start with Jeff. And to codify or not to codify, is that the question?
Thank you very much, Nicola. I think it is one of the questions, and the answer is that it would make sense to codify the UK Constitution. At the moment, there are a number of what we could call major construction sites of a constitutional nature in the Constitution. The view that convention or political usage has settled the principles that govern these areas is not tenable. These are not minor areas. The parliamentary sovereignty itself is being questioned in the courts, guarantees of the rule of law, the future of the Union, the process of constitutional change, the role of the upper house in the legislative process, as well as in scrutinizing government. These are all areas where there are fundamental elements of uncertainty. So I start with the first of three reasons in favor of a written constitution, and I think it is to provide clarity on some of the principles that govern or should govern these areas. Now, some say it's nonsense that a written constitution would do that, but I'm happy to demonstrate with examples because we're lucky in having an actual draft written constitution having been put before a parliamentary select committee, and we could look at what that constitution would have prescribed before the Brexit process happened. And you'll see that some of the great issues that were debated would have been resolved quite quickly under that constitution. The second argument in favor of a written constitution is we would have, finally, a formal process of constitutional change. At the moment, constitutional change happens like any other legislative change, if that. English votes for English laws came and went without any legislative intervention. I think that's mad, mostly for democratic reasons. Constitutions are fundamental, and they should be given that status and treated that way at a political level. We should be aiming for cross-party agreement on constitutional matters, because the primordial function of a constitution is to secure cross-community agreement on fair process for political decision-making. Lastly, I think formalizing the Constitution, engaging in the exercise, can give greater protection to some constitutional fundamentals. Most constitutions in Europe, we should recognize, can actually be amended with something as simple as an act of the legislature or an election or a referendum or some combination of the above. So I'm not talking about deep entrenchment. I'm against deep entrenchment for the UK constitutional order. But I think that the way in which the devolution arrangements, the principles were casually put aside for the UK Internal Market Act would not happen if a constitutional amendment were required to put that bill through. And I think more currently that the process of reforming the Bill of Rights, the Human Rights Act, could not happen under a written constitution, even if the amending formula was a simple majority, because you'd have to trigger a constitutional amendment process. And I think the case for rearranging the Human Rights Act would become, its weakness would lead to the death of that kind of casual reform of constitutional fundamentals. Those are just, that's my opening view on 3 reasons: clarity, a process for constitutional change, and giving greater protection to some fundamentals without going all the way to a super-amendment procedure for a supermajority procedure for amendment.
Nick, I'm going to come to you in just a minute, but just for clarification, what would codifying the Constitution mean for the doctrine of parliamentary sovereignty? Would it codify it, or would it do away with it?
In my view, it would. In my proposal, which I've written in an article, parliamentary sovereignty would remain, except that a law would be only insofar as Parliament would be able to amend the Constitution through a simple majority procedure. But it would be a constitutional bill process. In other words, there would be nothing supermajoritarian. But a law that is inconsistent with the Constitution could be struck down for that reason. It's just that it could be passed again through a simple majority procedure.
Okay. Do you agree?
With Jeff?
Yes, with the broader question of codifying the Constitution.
I think Jeff and I are at two points at extreme ends of a spectrum. So Jeff thinks that codifying the United Kingdom Constitution would be a great idea, and Jeff is the author of an excellent article in Current Legal Problems, which I recommend to you all, where he provides us with a structure whereby a written constitution could be produced, and also provides us with a strong argument as to why we would want to produce a written constitution. And I disagree with both of Jeff's claims. So this question, should the United Kingdom have a written constitution? It sounds like an exam question, doesn't it? It often is an exam question. I've set it as an exam question. And like all good exam questions, you should start by challenging the question. The question itself needs to be challenged. Why are you asking this? What sort of answer are we hoping to get? Because I think often when people argue for a written constitution or the codification of the constitution, they aren't really interested in the question of a written constitution at all. What they're interested in is constitutional reform. So this is a proxy question for questions like, should we reform the House of Lords? Should we have a new voting system? Should the Human Rights Act be made, should strong form judicial review be attached to the Human Rights Act? Should we become a federal state? All of these are good and important questions of constitutional reform. But you should ask yourselves, do they necessarily require the creation of a written constitution? Sometimes I think the answer is no. We can reform the House of Lords. We should reform the House of Lords without introducing a written constitution. We can reform the voting system. We probably should reform the voting system without a written constitution. Do we need a new Bill of Rights? Maybe yes, maybe no, but you don't need a written constitution to implement it. So all of these are interesting and important questions. They don't necessitate a written constitution. And the hazard of putting them into that bundle of a written constitution is that, it's bundling. You bundle together all of these different issues of constitutional reform into a single document, and then you put it to the people in a referendum and they have to take it or leave it. Whereas in fact, each of those issues should be treated separately, each treated on its own merits. Now, the great strength of Jeff's proposal is Jeff does provide a distinct argument for a written constitution. And Jeff's argument is grounded in democracy. Jeff says the important decisions in the state should be taken by the people. The laws should be produced by the people. And the Constitution, for Jeff, is the most important set of decisions and laws in the state. And Jeff argues that every 20 years we should have a constitutional convention to author a new written constitution because of the value of democracy. This is a good argument for a written constitution in the sense that it's coherent. It explains why you need that specific instrument, a written constitution. But I think it only identifies one of the tasks that constitutions can perform, articulating popular beliefs. It fails to recognise that constitutions also provide stability, that enables effective government, and also provides, they play an integrative function. They allow different people with different views and different ideas about the state to see their state reflected in the Constitution. So I'm against a written constitution for the United Kingdom, firstly, because it would introduce instability into our system. We would have a period of debate and uncertainty about the Constitution. We would have winners, we would have losers in the system. But secondly, and I think even more importantly, because it forces us to reach conclusions about issues we don't necessarily have to decide at the moment. Should we be a monarchy or a republic? Should we be a federation or a unitary state? Are rights more important than democracy, or is democracy more important than rights? All of those different ways of conceptualising the United Kingdom Constitution can be seen in its current structures, because those structures are broad, are vague, and are susceptible to different interpretations. If you produce a written constitution, you risk pinning that down. You risk creating winners and losers. You risk people failing now to identify with the United Kingdom as a state, because their vision of the state isn't one of the ones that the Convention has adopted. And you might think, well, Nick, we're not all that worried about that. Those are issues we can address. But just think about the costs involved in this process. The devolution settlement would have to be completely reopened. We would have to start afresh if we had a constitutional convention to reauthor the Constitution. Now, I don't know if anybody here is from Northern Ireland or studies Northern Ireland, but I understand it was quite tricky to work out a constitutional structure for Northern Ireland in the first place. Imagine if the consociational structure underpinning Northern Ireland's legislature was thrown open and questioned, and worse still perhaps, was re-evaluated from the United Kingdom, the English perspective. Well, I've got lots more to say, but I will stop there.
On your last point, I'll move over to Stephen now. Would you have to reopen the devolution arrangements, or would you be giving them sort of greater constitutional standing, I suppose, than just a simple law of Parliament?
It seems to me, Nicola, that the issue of codification really does bring up the territorial nature of the Constitution, and that the uncodified Constitution has served the territorial nature of the Constitution in a particular way, and that the process of codification could stretch it to breaking point. It seems to me a constitution performs two functions, a legal function and a popular function. So as a legal order, clearly it transforms political power into lawful authority. So it's a form of alchemy. It's alchemy insofar as it takes political power and gives it the legitimacy of legal authority. But that's a heavy task, and it requires broad shoulders. It requires a lot of legitimacy it gives legitimacy to a political system, but it also requires that the Constitution itself derives a lot of legitimacy. It seems to be further that constitutions, because they are essentially functional, derive that legitimacy from the particular people whom they serve. And it really depends upon them reflecting the will and the identity of the people whose lives they order. It also follows from that the process of transforming a political system through a constitution and through constitutional change must also take place in a vernacular way to reflect the nature of the society in which that constitution is being born or through which it's being changed. So constitutional change is actually a massive issue. To take an example from Canada in 1982, Canada repatriated the constitution back from the United Kingdom. This in itself, and Jeff knows much more about this than I do, but the substance of it was not actually controversial. The substance of what was going to be in the post-1982 constitution was not controversial. What was really controversial was the amending formula. What was going to be in the constitution in terms of how it would change into the future, because how it would change into the future called into question the we of who would be involved in that process of change. And I think this is the crucial thing about a constitution and a process of constitutional change. It's not just about creating a new legal order. It's a declaratory moment. It's a declaratory moment when that moment of legitimacy comes to the fore, where you don't just get a new set of rules. You have authors of those rules saying we are a collective we who author this new system. Now, in the United Kingdom, we've left constitutional change to the Crown and Parliament and Convention. Partly that's happenstance as a consequence of no revolution for 300 years. But I think it's also a recognition of our particular societal pluralism. it seems to me that there is this ongoing reflexivity in our constitutional system that has left the we question to one side. It has largely avoided the declaratory moment. If you look at Northern Ireland in 1998, when the Belfast Agreement went to a referendum, again, it largely parked the identity issue of Britishness and Irishness. I argued in an article that the people who voted in the 1998 referendum in Northern Ireland did so as a public rather than as a people. They agreed to come together for that precise moment to agree on a peace deal. They left thicker, bigger questions of identity and national identity to the side. So when I say that the uncodified constitution has served us well, this is not an appeal to nostalgia, to non-rational arguments for a Burkean perfectionism. Far less is that a claim to the genius of British constitution making, that constitutions are for less civilised people who need them, we don't. Quite the opposite. It's precisely because of the messy and complex societal particularity of the United Kingdom that we've not confronted this grand constitutional moment. So the British Constitution is unarticulated, contested, and constantly changing. But I think that reflects the fact that our sense of self, or of selves, are also those things. So it seems to me that an uncodified constitution facilitates the very fact that the pluralism, that the identity you would need to, the common agreement on an identity you would need to form a written constitution is simply not there. And to try and search for it, we could push the whole system to breaking point.
But Stephen, is the logical conclusion of what you're saying there that perhaps even with hindsight we may well have pushed the thing to breaking point by going beyond what you're suggesting there and leaving it to the Crown and Parliament, but increasingly big constitutional changes are preceded by a popular vote. So we have seen increased use of referenda and all the complexities that entails when you have the plurality within the country. So are you suggesting there that we shouldn't have put the issue of Brexit to the people, but left it to Parliament?
That's a very good question, Nicola. I think referendums are problematic from that perspective, because a referendum presupposes the pre-declaration of the we who are voting. So you can do that without bringing up the thick question, as Northern Ireland did in 1998. But when it came to the Brexit referendum, and that's why there were statements, for example, by Nicola Sturgeon, that a referendum in these situations should have been a pluralistic exercise. And it's interesting that in federal systems that have referendums, certainly in Australia, a referendum does require a double majority. Not simply a national majority, but a majority of the states. So yeah, a referendum within that system is intensely difficult.
Kate, it's not just the amending formula, the way you change a constitution that brings in the issue of the people, but actually the making of the constitution too. And you have some salutary insights, I think, from the experience in Southern Africa to share.
Yes, thanks, Nicola. And so speaking as an outsider and somebody who watched a codified constitution being made firstly in South Africa over a sort of 6-year period, it was a long, slow, complex political process. I can say that both the making of a constitution and a codified constitution can be extraordinarily salutary in very difficult circumstances. A lot of what Jeff says about identifying constitutional fundamentals, finding ways to go forward as a polity, have been the South African experience. You could say that at times it frays at the edges, but I think all democratic environments are contested environments. That's the project of democracies, is to take our contestation and make it public and engage with it in public spheres. So the fact that there's contestation in South Africa doesn't bother me that much, because I think that's part of what having built a democracy is about. So in the South African experience, I think codification has been very, very positive. But I think what's important to realise there is the very specific circumstances that led to codification in 1990. South Africa was effectively in a state of civil war. There was an oligarchical, racist apartheid government in power, and when they decided that they were going to enter into negotiations with the liberation movements, there was a strong realisation that what we had as a constitutional system was going to have to be really rethought. And I think for both sides it was a case of saying, we cannot continue as we are. We have to change. We are being compelled into this process. And being compelled that way into the process, willingly I think on both sides, led to what was in fact a very robust constitutional debate and has produced, I think, a pretty robust constitutional framework. The question is whether, in the absence of such crisis and kind of deep disruption in a society, one can have the same positive process. And that, at the end of the day, is not a legal question, it's a political question. In some senses, I tend to agree with Stephen that what one does need to realize is that it is a disruptive process. The South African constitutional making process broke down quite dramatically several times along the way, and it looked as if we might well return to the state of effective civil war and impasse that we had been in 1990. But each time, fortunately, the leaders got back together again and restarted the process. Those disruptions in the process, however, should make one realize that these conversations are very deep-seated and are inevitably somewhat disruptive. If, however, you can build the political will across a polity, and that would be both the constituent parts of the United Kingdom, but also across the array of political debate, then it could indeed be a constructive process. It seems to me to be that's a question for the UK to answer. If one doesn't have that, and there have been other constitutional codification processes in Southern Africa in the last 20 years, where there hasn't been that sense that there's been a coming together, a joint political will, as it were, to build a new constitutional framework, then they are not as successful. So that happened in Zambia, that's happened to some extent in Zimbabwe. Pretty good constitutional texts, but without the sort of unified sense of this is the document about which we are all going to work to build our constitutional framework. In the absence of that shared political will is a real threat, I think, to a process of codification.
Thank you. Jeff, I'm going to come back to you because you've been invoked in the others' contributions, and I'm sure you would like a right to respond. But we're also getting lots of questions in through Slido, so just a reminder to everybody, you can use the Slido thing. I can't tell you how to do it, I'm sure you know by now, to pose your questions, and I will try and bring in as many of those as I can. The most popular one of which, though, is without public appetite and demand for a written constitution, the political parties are very unlikely to commit to delivering one. Why should the public care?
Well, they should care whether the fundamental laws of the country they live in can be changed at the whim of a political party that has just over 30% of the popular vote behind it. If that's not the case, then I don't think that person's citizenship duties are being exercised properly. They might take the view reasonably that it would be a disaster for the kinds of reasons that Nick and Stephen have pointed out. But I think to say there's no appetite, who cares, to ignore the fundamental question of principle and of practice. I mean, let's not pretend that everything is okay in these areas. As I said, there are many construction sites for the Constitution right now. The system of public law was nearly reformed. The process, the Bill of Rights was nearly reformed. House of Lords reform was shelved. We had a very chaotic process of Brexit that would have been less so in a different polity. And the case for nationalism in Scotland has been fortified through this procedure. And we seem to be, meandering towards the breakup of the Union.
But isn't that a case for electoral reform?
So I'm glad you raised that, because Nick said, why not just do this piecemeal? And I do address this in my article. The fundamental problem with piecemeal reform in this constitutional system that we have is that you need to get one of the two parties, and probably both, to agree to reforming something that gives them tons of power. And they're not going to do that. Nick said, why don't we just change the voting system? Well, the Liberal Democrats tried to get a referendum on proportional representation, and they couldn't get it. So they got a referendum on the alternative vote instead. Fixed-term Parliaments Act was grudgingly accepted by the Conservative Party, which decided to get rid of it shortly after another term in office. The House of Lords Reform Bill in 2012 was killed off through a backbench revolt in the Conservative Party. So, and why do these things happen? Because why would, in a system in which two parties share in virtual absolute power, political power, why would they want to change something? You need a system that gives the choice of how the structure is organized, that takes that veto trump card out of the hands of both of the major political parties.
suppose one could argue that Liberal Democrats might have driven a harder bargain in coalition negotiations, but we'll leave that one for now. Well, question from Professor Vernon Bogdanor, who is pointing out that of other democracies without constitutions, the population of New Zealand is half that of Greater London, and Israel is developing one. What makes the UK so unique?
Well, this is a very interesting argument from Professor Bogdanor. It's the argument that says that everybody else has done something, so we should do it too. And I think one of the worries about that argument is that it isn't actually the case that everybody else has done it. So if you look around the world, it's true that there are only 3 countries that lack a written constitution, the United Kingdom, Israel, and New Zealand. But lots of the countries that have a written constitution with a capital C may as well not bother with it. If you go and have a look at the constitution of North Korea, a constitution with a capital C, it is a marvellous work of fiction. If you read that constitution, you would think the North Korean people were the luckiest people in the world because their constitution is so liberal and full of rights and democracy. In fact, of course, the North Korean constitution is just a sham. It's just something that's put there to fool the gullible who might come across it on the internet. So it isn't the case that most countries in the world, or all the countries in the world apart from those 3, have a written constitution that is effective. It's the case that they have a document that has got the capital C at the top of it and a set of rules underneath it. Every constitution with a small c, that is the assemblage of rules that animate the state, every country has one of those. And the gap between the written constitution with a capital C and a constitution with a small c can in itself be problematic. Maybe North Korea would be better off if it didn't have a constitution with a capital C, because at least people could actually see the rules that govern the state. Now, I also wanted to respond, if I may, to that question that was put to Jeff about people not being all that interested in a written constitution. And I think the people are right. I side with the people on this one. People don't care about the lack of a written constitution because they realise that there are bigger and more important problems facing the state. If you think about the challenges facing the United Kingdom at the moment, the question of whether or not we should have a written constitution is right the way down the list. And I'm going to say something now that's really controversial, so I want you all to brace yourselves. The United Kingdom constitution is a terrific success. It's really successful. It's worked incredibly well. Now, I suspect all of you in this room, because you're interested in constitutional reform, I can see you all leaping up and storming the stage. But reflect. Think to yourself, what other constitutions are better and more successful than the United Kingdom's? I'm not saying the United Kingdom's constitution is perfect, but I am saying that if you lined up every constitution that's ever been in the history of mankind, the United Kingdom constitution, in terms of producing stable, effective, decent, democratic government that tolerates and respects people's rights, comes very high indeed on that list. So I think people aren't worried about the written constitution because, in contrast to Kate's example drawn from South Africa, there is no pressing need for us to adopt it, and the constitution we already have is successful. And of course, people's lack of interest in a written constitution would carry over to the process of producing that constitution if they were forced, compelled into one of Jeff's conventions to author that constitutional document. Perhaps a large percentage of people in that convention wouldn't want to be there, wouldn't be interested in the outcome of the convention. And what consequence would that then have for the product of that process? So we should trust the people that they're right about this issue. We should be cautious about forcing them to address questions they don't want to address, and perhaps we should turn our attention to areas of the United Kingdom Constitution that do desperately need reform, like the House of Lords, or like the federal question that Stephen is raising, which we should be focusing perhaps more tightly on than this broad question of a written constitution.
Okay. Stephen?
Yeah. To me, it's not so much, the codification versus non-codification issue, but how well the Constitution works. So, quite often you'll go abroad and people will say, what do you do? And it's, well, I'm a constitutional lawyer. And they say, what, from the UK? What do you do all day? You don't have a constitution. And then we say, well, we do. We just haven't written it down. And they say, well, is it all in songs and stories? Or, and the point is that the Constitution is essentially functional. And the issue really is our Constitution performing the task of constraining political power the way it ought to? And Jeff and I serve together as legal advisors to the Constitution Committee, and we agree on many of the functional flaws of the Constitution. We maybe come to solutions in a different way, but what I really like about the way Jeff presents his argument is that it's very nuanced and it's very much shaped around the system we have rather than some ideal system invented on a blank sheet of paper. So I think there are a lot of flaws that we do identify. For example, the exercise of prerogative powers. And we've seen fundamental issues arise in the nature of not simply the prerogative, the prorogation issue, but dissolution through the Fixed Term Parliaments Act, but also huge issues now in terms of how executive powers have been marshalled in favour of the government. Now, we've heard panels earlier about this in terms of Brexit and COVID possibly being outlier situations. And maybe they are, we just can't tell yet. We can't tell if things will settle down, but we've seen massive increase in Henry VIII powers, in a lack of pre-legislative scrutiny, in the extensive use of draft affirmative procedure in bills, last-minute amendments coming forward, fast-tracking now for major bills rather than minor bills, the lack of sunset clauses in relation to the powers that are included, the use of guidance instead of delegated powers, which has no parliamentary scrutiny. And my suggestion is that a lot of these can be resolved by some of the things we heard in the previous panel about better parliamentary procedures, and in particular in the House of Commons not leaving constitutional scrutiny to the House of Lords. The fact that so many, as we heard, so many amendments come forward at report stage in the Lords, in a House that is often doesn't feel itself legitimate to deal with issues. So when it came to English votes for English laws, the House of Lords felt itself largely unable to speak. So I think a strong Constitution Committee within the Commons, not just simply PAC Act, but one that scrutinises bills properly from a constitutional perspective, something similar to the Secondary Legislation Committee. So so my point is that I agree largely with Jeff's diagnosis about a lot of the problems. We would come to different solutions, but I think the common ground is considerable in our diagnosis.
I know that you wanted to come back, Jeff.
Well, I wanted to just address something Nick had said, but also make a comment on the devolution question, because that came up earlier, and it's really the most difficult issue and the biggest challenge for anyone who, as I do, wants to advocate a written constitution. On the question of whether the people care about having a written constitution, there's polling on this question, and the answer is yes, they do. A majority, at least in the various polls I've seen, said they would like to have a written constitution. As Philip Norton has pointed out, that doesn't mean they agree on how to go about getting it. So it's not like that fact eliminates most of the hard questions that were being discussed. But people, there's a strong vote in favor of this, or a strong appetite for it. The Constituent Assembly, the Constitutional Convention that I proposed, and this is not far off other proposals, would be partly elected. Party members would stand in a closed list PR system, so they would have to be put up by their parties effectively to participate in it. And there would be a process of sortition for the direct appointment of citizens, basically. It's like jury duty. You don't have to do it. There will be large queues of people that would be very happy to write the Constitution for the country. I don't think finding willing participants in the exercise will be difficult. Getting the parties on side to do it in the first place is another story. If that can't be done, the whole thing folds. But I think if one party were minded to do it, they could hold a referendum on the question, and that would generate a strong force that a party opposed to the process would have to reckon with. Now, as for the devolved arrangements, I suspect, and I really defer to Stephen. Nick's written a wonderful book as well, talking about the territorial constitution of the UK as part of the constitution of the UK in a very deep way. I suspect politically the way this would play out, even in the Constituent Assembly that I've just indicated, is that the default process going in would have to be that either we would freeze the current arrangements and give them constitutional status, as Nicola was asking about, or to ratchet up the guarantees that are offered to the devolved authorities. I think we should dispense with the Sewell Convention and replace it with a strict allocation of competence that can be adjusted through amendment. Now, I don't just think that that is an ideal scenario. I think there are many complexities I haven't mentioned. I think this is exactly what would happen. And why do I say that? Any party that would seek to diminish the powers of the devolved assemblies, parliaments, or governments would be creating a political time bomb for the entire process of adopting a written constitution. And in the assembly that I'm talking about, which is 2/3 party members, the political sophistication of the membership is such that they will know that. And why would they participate in an exercise that has a poison pill right in it? So I think people would know that you can't adopt a position that will destroy the whole project, and they would reason in light of that. Now, you might say that's an article of faith, but I think it's political judgment that makes me think that that would be the case. It would be a time bomb to diminish the powers of the devolved legislatures. And there's a lot in principle and constitutional theory that would support actually making it stronger than it currently is.
I'm going to come back to the devolution question in a moment, but Kate, what would your suggestion be in terms of bringing the people into the process of constitution making? We had a question here that was in response to something that you were saying earlier, Nick, which was saying, isn't Professor Barber's assertion that we don't need a written constitution because it would require the resolution of difficult problems rather the point? And is the process of constitution making, particularly if you open it out, a way of resolving difficult issues? Is that the experience of Southern Africa?
Well, I think it can be. The thing is that it's not a dead cert. So that if you got to the sense where people thought this does matter, there are issues here we need to do, and I think it's right to look, for example, at the devolved powers as one of the key issues, but also the question of the relationship between the executive and parliament is another one, and that's not peculiar to the UK. That's a problem that's occurring in a range of democracies around the world. If people began to realize that that was an issue that people needed to talk about and think about, a well-managed process, much the way in which Jeff has outlined it, but I think also with a guarantee that there will be proper consultation across the society in quite deep ways, might well be could be a very constructive process in building a common sense of what it means to be the United Kingdom and how power is exercised within it. That, of course, does require real open-minded and fair commitment to the project. But if that were to happen, I think it can be so. If one looks again at the South African process, there were thousands and thousands of processes of consultation. And it meant actually that lots of ordinary people became involved in understanding, how the system worked, which certainly for the first generation post-constitution making was extremely healthy. People had really engaged with the project. But it does need a serious driving force to get there. And a commitment not to let centrifugality take over. We've got to make this work. There's got to be an important frame of mind.
Stephen, I'm going to come back to you here, partly to respond to Jeff's observations and suggestions around the devolution issue, but also, clearly, issues like the Sewell Convention are being challenged within the current context. Jess Sargent from the Institute for Government is asking whether there are ways other than the process of codifying the Constitution, which might raise other issues in the process. Are there other ways to address those sorts of challenges to devolution and to perhaps make it clearer and give more protection to devolution?
It is a difficult one, and things haven't been great. We saw that. We heard Carwyn Jones talk about the internal market bill. Another thing we're noticing coming through in bills, and to my mind it's happening too often to be an accident, is that the government is providing for delegated powers to be used in devolved areas. Of course, secondary legislation doesn't fall subject to the Sewell Convention. So is that a way of circumventing the Sewell Convention? It is, at least by accident. One hopes it's not by design. But if it is simply by accident, that's not great either. The problem with codifying a strict demarcation of powers, I think, well, there's several problems. One is it would be very asymmetrical across the 3 different settlements. It would also, in effect, give a veto power for those areas that are clearly devolved competence in the areas where the UK currently wants to legislate. And Nicola, in the earlier session, raised the point that you would then be subjecting a very, very big part of the country to effective ransom by small parts of the country. You might want that, but it's an issue. So it seems to me that the Sewell Convention is there to manage the fact that our system is very asymmetrical, both societally and in terms of powers, and that it takes account of the fact that with a very big country with only 3 small areas devolved, there are times when the UK just has to do stuff. But it should try and do stuff whenever it can with consent. I think the EU withdrawal bill was actually a pretty good example of that. When Clause 11 was initially published, which was basically everything was back to London till we've got time to sort things out. And by that point, everything in the withdrawal bill was all about retained EU law and the complexity of dealing with... Devolution was completely sidelined. Wales and Scotland erupted in anger, reasonably, and Clause 11 was completely rewritten so that most of the powers actually went to the devolved regions with, as Carwyn Jones was saying, some things left in the cupboard to sort out later. He didn't like how those things in the cupboard were later dealt with. But it seemed to me that that approach was a much more consensual, constructive approach, and that is the way in which our political constitution can function properly according to principles of respect and so on. So I think there are ways forward within the current system. I think the House of Lords Constitution Committee recent report, which uses terms respect and dignity in terms of the way the union ought to function, are there. It requires political will. But frankly, no constitution works without political will. And I don't think codification would do the trick if the political will isn't there.
But surely you need some sort of process, because it seems to me quite a long way from the EU Withdrawal Act process. We've had a whole series of things now, where it's become quite easy, it seems, to set aside the Sewell Convention.
The difficulty with the Sewell Convention is that it's a one-sided agreement in a sense, because the Sewell Convention says the UK normally won't legislate without consent. That doesn't take into account that consent can be unreasonably withheld. And if we were to codify the Sewell Convention, it would be codified presumably as a much stronger reciprocal agreement, whereby consent would... So on the EU withdrawal bill, Wales consented, Scotland didn't. I'm not saying who was being reasonable there and who was unreasonable. I mean, people have different views on these matters. But if we are talking about trying to codify what is a very delicate relationship in terms of political views, what we would end up with is perhaps the Canadian model of Section 91 and Section 92, where you try and list everything. What that leads to are 2 legal questions. So your courts are suddenly going to be clogged with, does a devolution issue even arise? If so, what is it? And then where does competence fall? So we would have to be prepared to completely transform our, in my view, effectively federal arrangement into one which is very heavily juridified. I think Jeff's aware that that could happen. He builds in protections, I guess, and he'll talk about them. But I think that could be a consequence. That's not something I would be in favour of.
I'll let you come back to on that, because we have a question also from John Newham about perhaps one of the consequences of having a codified constitution being empowerment of the judiciary, and how do we overcome that? I think from what you were saying about simple majorities in Parliament still operating would help to address that, although I dare say it would raise some other issues too.
Yes. I just wanted to say I tended, certainly when we worked together on the committee, I always followed Stephen on any question related to devolution, not out of deference, but out of pure respect. So I take very seriously all of those points, Stephen. The only one I would question is whether having a strict allocation of competences would lead to the courts being clogged with cases. When I did my law degree in Canada, we were looking at cases on those questions from 80 years previous. Yeah. So they settled. I also think that the courts don't have much of an appetite for that kind of litigation here. It could have arisen under the devolution statutes, and it really hasn't. But on the other points, I see the case that you've made. And this segues nicely into the question that you'd received about juridification of the Constitution. So I think that whether or not a Constitution leads to juridification has most to do with the approach the courts take to what kinds of questions they want to be adjudicating. There are many countries that have written constitutions where the courts are more deferential on political questions than they are in the United Kingdom currently. So all of the Scandinavian countries, the Netherlands, it's an open question about the Supreme Court of Ireland. I don't know if it could be described that way, but so a written constitution doesn't necessarily lead to juridification, and as we've seen under the devolution statutes, it hasn't led to the juridification of devolution, the law that applies in that context yet. I think it's likely that a Bill of Rights would be enforced just as it currently is under the Human Rights Act, although with a British Bill of Rights, it's possible the courts would be more timid than they currently are because they don't get nudged along by the European Court of Human Rights on a regular basis. It's a complex question about the relationship between a national Bill of Rights and the European Convention. In most countries in the system, the question never arises because the national bills of rights tend to be stronger rather than weaker. But that would be a question to be resolved. Ultimately, if people are not happy with the decision of a court, then a bill can be brought forward and passed by a majority on my proposal to change that law and to move it back. So prisoner voting might be an example. And given the nature of rights litigation and the, let's face it, unpopular position of many of the claimants that take these cases, getting a bill like that through the Parliament is not politically impossible. It's changing the Constitution or making something apply notwithstanding the Constitution is a big step. So there is a disincentive for it. But if we get the kind of case law you're getting in the United States, I have very little doubt that the UK Parliament would just reverse a court decision like that if it happened.
I have a question that's just open to any of you. It's the most popular question so far. Paul Evans is asking, is there a middle way? A corpus of statutes recognised as basic law and requiring strengthened parliamentary or extra-parliamentary procedures to amend? That seems to me very much a question for a distinguished group of lawyers present.
Nick.
Stephen? Oh, Nick?
I mean, my view is that, you know, there's not a hard line between a codified and an uncodified constitution. And we saw that in the constitutional statutes doctrine and things that emerge. The influence of the European Communities Act over 45 years in terms of constraining what Parliament could do. You know, the Fixed Term Parliaments Act, which began to introduce the possibility of supermajority, at least not in the lawmaking sense, but at least in a parliamentary procedural sense. The Northern Ireland Act, Section 1, which binds the executive to hold a referendum under certain conditions. The European Union Act of 2011, which sought to bind, you know, and we've seen it, and it hasn't even played out yet in terms of what the new trade agreement with the EU, when translated into domestic law, seeks to, ironically, bind not just the government, but possibly Parliament in terms of its future scope for action. So it does seem to me that we have moved towards a slowly more crystallised approach to a distinction between ordinary and constitutional norms. We may have sleptwalked into, or whatever the word is, but it seems to me that it is more a process of accretion, and we are moving in that direction. So I don't necessarily see it as a category distinction.
Oh, it's a very good question, and I agree with what Stephen was saying. I might even go further and say we probably already have reached that stage of having a special set of statutes that's more difficult than ordinary statutes to amend. The idea of constitutional statutes is now an established feature of the law, and the doctrine of implied repeal, it seems, doesn't operate against constitutional statutes in the way that it operates against ordinary statutes. So it's a little bit harder for Parliament to alter a constitutional statute like the Scotland Act than it is for Parliament to alter an ordinary statute. We might even very hesitantly, peering into the future, polishing up our crystal ball, you could see that area of law strengthening. If Boris Johnson tomorrow decided he wanted to repeal the Scotland Act without a referendum, without the agreement of the Scottish Parliament, I think it would be at least worth a go to take a case to the Supreme Court to argue the United Kingdom Parliament can't, even by express repeal, remove the Scotland Act without either the agreement of the Scottish Parliament or a referendum of the Scottish people. There are threads in recent case or in recent jurisprudence that you could draw on to manufacture an argument. You could say the Scotland Act is a special statute. You could say that repealing it was to undermine the democratic fabric of the United Kingdom. You could point to some Supreme Court cases where the judges have suggested that they might be willing to exercise review over Parliament statutes where they unsettle democratic structures. You could point to Jackson, you could point to AXA. So I wouldn't want to stake my house on the Supreme Court striking down an Act of Parliament that repealed the Scotland Act, but equally I'd be certainly willing to give it a run in the Supreme Court, and it might work.
Interesting experiment that would be, but as a humble political scientist, I wouldn't recommend it. Kate?
Yes, I think it's a very interesting question. I think one of the things is we shouldn't draw this very hard line between codification and non-codification. Really what's been happening in the United Kingdom, it seems to me, over the last 30 years, there's a whole series of processes of constitutional amendment, some of which are in statute or legislation, some of which are in convention, some of which are enormously creative and imaginative. Take, for example, Section 4 of the Human Rights Act. This was a really, I think, smart way of addressing the parliamentary sovereignty versus entrenching human rights, which, despite the often kind of just satisfaction with it, does seem to have worked extremely well, and Parliament has found it successful. So I think that what we should realise is that this drafting is a very ingenious and creative exercise, and I have little doubt that there will be ways to address, to build to continue this process, as it were, of constitutional development, which may move more close to a written constitution, maybe without the detailed process that Jeff is talking about, but in response to the changing character of this polity over time. So I think there's a lot of ingenuity that could be exercised here to produce something which feels more like a constitution, but which is very much rooted in British parliamentary practice, British constitutional experience, and successful.
And British pragmatism and muddling through.
Yes, that too.
I'm a little bit skeptical of. It is true that the line between the codified constitution and the uncodified norms at the core of the UK constitution, it shouldn't be overdone. In reality, the importance of a codified constitution is the status that it has amongst elected politicians and institutions. The fact that, nevertheless, I'm skeptical that we should not see any difference, or we should de-emphasize the very important difference that codification would make. So the idea that we would be able conceivably to take a case to the Supreme Court to challenge the repeal of the Scotland Act as somehow unconstitutional, next to the alternative of it being in a constitution and there being no question of anything like that being remotely possible, gives an illustration of the very real differences between the two. Same thing with the Human Rights Act. I've said this a number of times, but if you can't just disapply the Human Rights Act if it is written into your constitution like a Bill of Rights. When the Internal Market Bill was going through Parliament, there was a proposal made at a very, very late stage of the process to disapply the application of Section 6 of the Human Rights Act, which means that the proposal was that delegated legislation adopted under that act relating to the Northern Ireland Protocol could be subject to a declaration of incompatibility but not struck down. Now, that is a fundamental constitutional change, okay? And this was introduced at the report stage, very late at night. They were planning to effectively amend and disapply the Bill of Rights at that stage. Now, I think that shows just how easily the existing norms can be displaced certainly in a crisis, but sometimes even in business as usual. Retrospective legislation is another area that when we were working on the committee, it happens all the time. And it's done casually, it's not even mentioned in the explanatory notes. And when you raise it as an issue, the response of the government is, well, it makes sense, doesn't it? And that's about how deep the issue runs. So I think that there is a difference, that codifying gives a status to these norms that makes it harder to put them aside, even if they can ultimately be put aside through a majoritarian process.
We have a question here and an observation, really, that we've been talking about the Constitution all day, and nobody has really talked about the monarchy in that. And the question is, does that suggest that the monarchy is irrelevant to governance and the Constitution of the United Kingdom? And if I can extend that out a bit, at the point at which there is a transition to a new head of state, which will happen, is that potentially a trigger for some of these wider constitutional issues, or do you see it separate, Nick?
Thank you. I mean, I'm always amazed by the fact that we don't talk about the monarchy in United Kingdom constitutional scholarship. Well, we do, but we start to talk about it in extreme detail and complexity. And very rarely is the question, should we continue to have a monarchy raised in constitutional discussion? And it is a question that ought to be raised and ought to be discussed. Monarchy is really interesting. So at the start of this discussion, we were talking about the way in which you can have different stories inside a constitution and the way that can be a strength. And one of the great strengths of the United Kingdom Constitution is, I think, that, as Bagehot pointed out, it manages to be a republic and a monarchy simultaneously. So if you're a Republican, you focus on the creation of citizenship, where we've all been designated as citizens. You focus on the Equalities Act, you focus on the House of Commons, you focus on elections and votes. If you're a monarchist, on the other hand, you focus on the Queen and the Crown and Buckingham Palace and all that sort of thing. This is a really good example, I think, of accommodation within a constitution as a way of avoiding constitutional disagreement. You have these two stories running alongside each other. But make no mistake, these are two profoundly conflicting stories. So the idea of the republic idea of citizenship is the idea that everybody in the state is equal, and it's grounded in a notion of the essential moral equality of people. The idea of monarchy, on the other hand, is grounded in the idea that one person is special, and special by virtue of birth. And I think the only way in which monarchy can make any sense is if we've got a religious idea in the background that God has picked somebody out. So I think we ought to be addressing monarchy. We ought to be thinking about the tensions it has with citizenship, but perhaps we should be a little slow to rush to become a republic, because monarchy provides a story of the United Kingdom Constitution that is attractive to many people and leads them to identify with the Constitution, maybe for bad reasons. And that's a terrific asset, because it persuades people to accept the decisions of our constitutional structures because they see it as part of a monarchical structure.
Yes, I agree with Nick that it's a very important topic for constitutional lawyers to talk about. And I also think, as he has illustrated, that it just shows the complexity of trying to codify the Constitution in a way that would not be divisive, because you could see that this could create an enormously divided society between the people who say we are first and foremost citizens of a republic and others who'd say otherwise. That said, however, it is surprising how many written constitutions accommodate precisely that sort of ambiguity within them. It doesn't mean that simply because you're writing down a constitution that you will actually eliminate all forms of ambiguity. And I'll just give an example. In the South African Constitution, we accommodate the system of traditional leadership. That is, traditional African customary forms of leadership is recognized in the Constitution. This is a Constitution which says its founding value is democracy, and there is that exact ambiguity there within the Constitution. And that is worked out in a whole range of ways, both within parts of our society where traditional leaders have authority, within courts, and within Parliament, where Parliament seeks to legislate to regulate traditional leaders. So I don't think we should think simply because there is contradiction and conflict that that automatically means you can't have a written constitution, but obviously it would have to be dealt with in a delicate manner, recognizing that here you are dealing with something over which there is disagreement and in which perhaps, as it were, managed ambiguity needs to be retained.
Stephen?
Yeah, I mean, Baja also talked about the Constitution having the dignified and efficient dimensions, and it seems to me that the dignified bit translates into what I was calling the popular bit of the Constitution, the symbolic part. And again, if we came to the process of drafting a codified Constitution, the monarchy would arise, because to what extent does the monarch as head of state symbolise a focal point of identity for the country? Well, it does for many, but it would be a particular problem in Northern Ireland, for example, in terms of drafting a new constitution in that respect. And actually, the political constitution has been quite good at managing that. So the Church of Scotland Act, I think in 1921, expressly provides the Queen is not the head of the Church of Scotland. So the political constitution has managed the sort of dignified part in subtle ways. I think what's very important is that we move away from the monarchy being involved in the efficient part. And we thought we largely had with the fixed term parliament. But we've seen recent examples, I think, of dangerous discussions. So there was the prorogation case. Should the Queen have been put in that situation? Could she have refused prorogation? Some talk about refusing royal assent. Bonkers views being put forward in that respect. And now potentially the Queen being brought back into dissolution discussions. With the repeal of... So I think those things, you know, we could call it codification or otherwise, but I think those are things that should be removed beyond the role of the monarch.
Sorry, do you want to come back on that point, and then I'm going to come to Jeff? But yes.
Oh, just a very brief point. Constitutional monarchy is a particular form of a constitutional... I think it's a time-limited form. So sooner or later it goes wrong, because the monarchy is meant to stand apart from politics, and that sounds like a really interesting, easy job to undertake. And the Queen has been fantastic at doing that. She's performed her role in an exemplary fashion. But it's actually a really difficult task to remain politically neutral whilst you're appointed to your office by right of birth and live in a mansion and wear a crown. So sooner or later in a constitutional monarchy, somebody comes along who lacks the skill to execute that role. And one day we're going to have to address this. Sooner or later we're going to have somebody who's by right of succession the monarch, but isn't temperamentally suited to undertaking that role.
And might that trigger wider constitutional issues?
I'm not sure that would be the trigger point. I mean, first of all, there's no problem to have the monarchy written into a written constitution. That is the case in many countries. The actual political position of the monarchy in this constitution reflects much of the balanced constitution, actually. The coronation oath is very interesting to have a look at. It reflects this relationship that has evolved between the Crown and Parliament. And functionally, the monarchy takes the PM off a pedestal in a certain way. It provides a certain degree of humility to the post of Prime Minister, the office of Prime Minister, which I think is important. So it's a slightly difficult question. I would probably myself prefer to not live under a monarchy. I would. But in this process, I think that it should be discussed, but it won't go anywhere for two reasons. First, republicanism is just not popular in the country, as far as I'm aware. And the complexities are quite significant, especially for the Commonwealth, but also for the established church, and then the way in which the Crown serves as the vehicle for the execution of so many functions in the Constitution. And the combination of that unpopularity and that complexity, I think, would sink the whole project.
One of the challenges, and we've touched upon it in various contributions, of any sort of codification of the Constitution is how you change it. And from the Canadian perspective, this has been deeply problematic. How would you, in the context of the UK, propose an amending formula for the Constitution that would most likely, if not overcome the issue of winners and losers, which is inevitable, but at least perhaps get losers' consent?
I think that a formula which is that there would be a constitutional bill put before Parliament through a special parliamentary procedure, which, if passed by a simple majority, would thereafter be put to a referendum. That this procedure is appropriate, it's not supermajoritarian, and it would have to be taken very seriously, so amendments wouldn't be done lightly. And I think that constitutional referendums, despite their lack of popularity now, are appropriate and defensible, and I commend Stephen Tierney's work on this. I don't know if you've changed your mind on constitutional referendums, Stephen, but I think there is a role for them in the Constitution.
But on a UK-wide ballot, or one that has and requires majorities in different parts of the UK?
I think that the amendment of the devolved portions of portions of the Constitution dealing with devolved legislatures and territories would need its own bespoke procedure, probably at the very least with concurrent majorities, in any case probably with a veto right in that of the people in that territory.
Okay. Stephen?
What I was interested in, Jeff, do you don't mind if I ask Jeff a question?
Of course, go ahead.
It's not so much in terms of how the Constitution would change, like about how the codified Constitution would come about in the first place. Because I think you see a role for a kind of constitutional convention. Would that be fair?
Yeah.
Could you maybe, I think people would be interested in.
So I think that in that process, the UK government and Parliament would need to be consulted, but should not have a veto power over the process, because both are dominated by single parties, and I've already explained why I think that's a problem. It would probably follow then that the devolved governments and assemblies, parliaments, in the two cases of Wales and Scotland, would also be consulted, but would not have a veto right. And so I think this is where Stephen would take me to task. I think that the citizens of all parts of the UK should elect from the parties in those areas, as I said, on a closed list proportional representation basis, so the parties could put forward their luminaries for election, and that the 2/3 of the assembly would be composed in that fashion, 1/3 through sortition.
Yeah, interesting.
But that does go back to the issues that you were raising, Stephen, about who are the we, and the inevitable asymmetries of the UK make that quite difficult to generate consensus, don't they?
That's my sense, and I think there are. I mean, look, this is no secret. There are political forces in the UK now who wouldn't want to make it work.
Indeed.
Yeah.
And they're powerful forces. And were there to be a referendum on this new UK constitution, others might well use that as a vehicle to put forward referendums on something else. And it's like a nice constitution, but not for us. Thank you. So that would be a possibility.
Yeah.
I'm also interested in the convention process. I mean, I think this is the Australian model, when they had the convention on a republic, used the parties plus popular election. So they used a mix of civil society plus political parties, and it seemed to me that was a more realistic approach than the Canadian approach to electoral reform, which went down just citizens' assembly route.
Absolutely.
Which risks so much elite capture. And also then, in my experience of the Canadian system, when it came to the referendum, it was very hard to move from that micro process of a little citizens to get buy-in from the public.
Exactly.
So that's another big issue, how you get the public who are going to vote in the referendum to take an interest in this. Yeah.
Indeed, and I think it would have to be through political leadership, and I think that would be absent if the parties didn't. But I think the case for the parties having a predominant role in the process is not only for political buy-in, but also because politicians have expertise in the art of the possible, and it's important that that actually predominates. The key, I think, is that the formula is such that neither in this constitution, the Conservative Party or the Labour Party, can dominate the process.
Interesting.
Well, one of the values of the citizens' assembly type approach is the learning part of that and the deliberation that goes with that too. And that's a positive, isn't it?
Indeed.
Their experiences from Southern Africa with citizen buy-in and civil society buy-in?
Yeah, but one comment first on citizens' assemblies, which we didn't use at all, is that I think very multi-issue kind of problems put to citizens' assemblies are much more difficult than more limited ones, because clearly the array of things that have been talked about are very difficult. And it's the same problem with the referendum very often, and one has seen that in some jurisdictions where a constitutional Bill of Rights, for example, was put to a referendum in Zambia and failed. Probably because of dissatisfaction with just small parts of the Bill of Rights, and this can lead itself to kind of a political kind of dog in the manger attitude, which doesn't necessarily mean that people don't broadly support it, but there's one or two elements of it which have become very controversial. So I think multi-issues before citizens' assemblies can be very, very difficult. In the South African experience, and outside of Zambia, generally in the Southern African experience, there's relatively little use of referenda. It's generally through either forms of citizens, conventions, not with sortition. I think Jeff's idea of sortition, in other words, having sort of, as it were, kind of jury service for a portion of it, where people are identified, it's a little bit like mixing a citizens' assembly into the convention, and will give a kind of vox pop element to it, which might be very valuable, and also make ordinary people feel somewhat connected to the process. And we have seen that in citizens' assemblies, for example, in Ireland, where ordinary people watched the process and actually began to trust in the process. And there's really interesting data that came out of the abortion referendum, which suggested that people who were uncertain about how to vote in the referendum were influenced by the way in which the Citizens' Assembly had concluded and actually voted in the same way. So I think that can happen with the use of sortition in the process. As I say, I think I am more cautious about referenda. They're clearly a legitimizing exercises, but it doesn't seem to me that they're necessarily legitimizing exercises. I think they can at times become particularly in multi-issue things, very, very difficult and problematic in divided environments.
I'm going to come to you in a minute, Nick, on the spot, but I want to bring Stephen back in on that particular point
referendum.
There on referendums, because we saw in 2014 the experience of quite a deliberative process combined with a referendum that did seem to inform, and you did a lot of work on that.
Yeah, I think I would agree with Jeff on this, and maybe not so much with you, Kate. Precisely, I think a referendum in a very, very contested polity is very difficult, because you have to get the self to agree to vote. But the self can vote on a contingent basis. It needn't agree we're all British or we're all, in the Northern Ireland example. But you can agree to vote for an issue that elites have got together and agreed on, contingently, parking your identity, and maybe not forever. So the two sides voted for the Belfast Agreement. It didn't mean they were relinquishing long-term claims to reunification. But for that moment and for that time, they were agreeing. And I think it lent a legitimacy. Northern Ireland hasn't been great since 1998, but I think it would have been a heck of a lot worse if there hadn't been a cross-province referendum in which clearly a majority of, and that wasn't a part of the official numbers, but clearly a majority of both communities, in very different proportions, voted for it. So my sense is very much with Jeff that a referendum might be very hard to hold. If you do it badly, it can be disastrous if it's seen that one side wins, and it can polarize like Bosnia. But for something as big as this, I think it's the only way to legitimize something.
Nick, Kate was saying that referendums or citizens' assemblies are quite difficult vehicles for something like a constitutional change or a codified constitution, which is a multitude of things, and that resonates with the point that you were making earlier about how it's better to deal with things in a piecemeal fashion rather than all at once. And we have a really interesting question here by someone who remains anonymous, saying, agreeing with you that it would be better to take on the big questions piecemeal, but how do you get the pressure to make that happen through a constitution? How does it happen unless you initiate a process? And you're right about your earlier point about a lot of this is really about people wanting constitutional change. I remember as a student, I'm sure my age here, but it was all the Charter 88 things, and it was all about, in the name of a written constitution, wanting change. But how do you get to that point if you don't have an exercise like this?
That's a good question. Can I first say, we've all been discussing Jeff's paper during this panel, and I think it's worth saying, I think, Jeff, your paper is available on open access, isn't it? And it's extremely well written and clear. So it's...
Thank you.
Jeff King, is it The Democratic Case for a Written Constitution?
Yes.
So I disagree with every single line of that article, but it's an excellent paper, and I would strongly recommend you read it if you're interested in the question of a written constitution. Now, we've seen a number of problems, I think, with a written constitution coming forwards, both in terms of how it's produced and what it contains. And I think this bundling worry is a real one. If we review the entirety of the Constitution in one go, we treat House of Lords reforms, voting, devolution, federalism, Human Rights Act, all of a bundle, and then we present it to people in a referendum, and they have to either take it or leave it. And I think that is problematic, and for the reasons Kate gives, it can sometimes mean that good, sensible constitutional reform proposals are lost because of a few outlying things that draw the attention. How do we galvanise people's enthusiasm? How do we make people care about constitutional reform? Well, firstly, I don't think we should be too worried if they don't care about constitutional reform. Maybe they don't care about constitutional reform because they don't think it's the most important thing the government should be doing. Jeff told you about an opinion poll earlier on which asked people, do you think we should have a written constitution or not? And Jeff tells us the answer was yes. But perhaps a more significant poll would have been one where people had to list the things they thought were important. Reforming treating the deficits in the NHS, for example, inflation, house prices, the public sector, the crisis in the public sector. And if we had a list of issues of importance, where they put a written constitution on that list, and I bet it would be right at the bottom, even if you managed to scrape into the top 10 or the top 20. And that's because this isn't what the state should be focusing its attention on. There are other issues that are more pressing. And creating a written constitution would suck in an enormous amount of political energy and political time and would distract us from these other issues. Now, having said all of that, and having argued against Jeff's proposal, and having pushed you against written constitution, there is one area where I think there's a good argument to be made for the creation of a written constitution, and that's in the area that Stephen is an expert in, federalism. So I think if you think that we need to move towards a federal settlement for the United Kingdom, maybe we would need to have something very like a written constitution to make that possible. And I was, as it were, defending the popular apathy about the question of a written constitution a moment ago. There is one area in which I think the popular apathy is seriously misplaced, and that is the question of the English. And I don't know if Vernon Bogdanor is still listening to this, but this is an issue Vernon has written about at great length. So the lack of devolution to England is a time bomb waiting to explode in the devolution settlement. The West Lothian question is one that people radically underestimate. I'm sure you all know what the West Lothian question...
No, it's just I'm conscious of time.
Ooh.
So and that could open a whole other can of worms. So we have come to the end of our time, and there is a keynote waiting. So sorry to cut you off there in your prime. There was what I take to be a rhetorical question there at the end about perhaps the antipathy to a written constitution was because of the role of constitutional lawyers, like those distinguished in interpreting the constitutional arrangements, although I think regardless there would be a critical role for constitutional lawyers anyway, and I am absolutely grateful to have them playing that role. So if everyone can thank the panel in the usual fashion, thank you very much.